Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about perjury. Cases that should have gone to the Supreme Court of Canada, but didn't. Robert Vanier was accused of perjury after allegedly filing a false affidavit in the course of an administrative proceeding that he was involved in. In order for a perjury conviction to be sustained, the affidavit or statement made under oath has to be made in a capacity where it was either compelled or required or permissible under a statute. And there was no particular law that actually made it compelled or required or permissible under the regulations related to that administrative hearing through which an affidavit could be provided. However, there were rules of procedure that were not codified in law, but simply the procedures that the tribunal created for itself that did permit this type of evidence to be received. And it was as a result of those rules of procedure and the fact that they existed that permitted Mr. Vanier to be convicted. And this case obviously raises very important issues, because as soon as you get into exposing people to potential criminal liability for very serious offenses against the administration of justice, in circumstances where they are not complying with the black letter of the law, but instead rules of policy and procedure that tribunals create for themselves, you delve into areas of significant uncertainty. Tribunals have a wide latitude to create policies and procedures that apply to the work that they do to facilitate the statutory function of the tribunal. And it was on this basis that the court determined that this was essentially permissible under the legislation, even though the legislation was not explicit. This seems to run counter to rules the Supreme Court of Canada has already established with respect to tribunals, that tribunals only have the powers that are prescribed to them by statute. And although policy making doesn't have to be prescribed by statute and rules of procedure are implied, if the powers prescribed by statute is what the criminal code is referring to, and any ambiguity in the criminal code legislation should be resolved in favor of the accused, taking rules of procedure or policies that permit people to do things like file sworn declarations or affidavits or solemnly affirmed statements or make solemn affirmations or give testimony under oath is taking things out of the black letter interpretation of the criminal law most favorable to the accused and creating very murky waters, especially because tribunal policies and procedures can change significantly over time. And at the end of the day, because policies and procedures are not written into law, it is in any given case up to the discretion of the decision maker whether to apply those policies and procedures in an individual hearing. And this raises concerns that in one context, somebody may be charged with perjury for filing a false affidavit, where in another, if they prepared a false affidavit that was refused by the tribunal, they wouldn't be charged, even though the conduct is effectively the same. It is the same intent to mislead. These are the things that the Supreme Court of Canada ought to have sorted out. And unfortunately now, it leaves this particular section of the criminal code subject to different interpretations depending on the circumstances and the forum in which the perjured or untruthful evidence is received, which could have the potential to create chaos. The only saving grace for this is the fact that perjury charges are fortunately very rare in Canadian law, and therefore the likelihood of another case like this going to the Supreme Court of Canada and the Supreme Court of Canada having the opportunity to assess a case like this is also going to be very rare. Hopefully the Supreme Court of Canada does have the opportunity to really rein in the way in which tribunals can influence the outcome and procedures followed in criminal cases by finding a case like this to decide these issues in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.